25, defendant Joshua Sanchez Lopez was charged with grand larceny of a motor vehicle in the Las Vegas Justice Court in Clark County, Nevada. A summons was issued in lieu of arrest, but Mr. Sanchez Lopez did not appear in court for his initial appearance on December 2nd, and a bench warrant was issued for his arrest. Mr. Sanchez Lopez was arrested on January 12, 2026. Judge Eric Goodman set bail at $25,000 and ordered that, upon posting bond, Mr. Sanchez Lopez be released to the electronic monitoring program operated by the Las Vegas Metropolitan Police Department, the consolidated agency commonly referred to as Metro that polices Las Vegas and unincorporated Clark County under the elected Clark County Sheriff, Kevin McMahill. On January 29th, Metro informed Judge Goodman that it would not release Mr. Sanchez Lopez because he was too high risk, citing his prior bench warrants, failures to appear, and program violations. On February 5th, Judge Goodman ordered Metro to release Mr. Sanchez Lopez within 24 hours. Instead of releasing him, Metro and Sheriff McMahill filed an emergency motion for the immediate stay of the release order. On February 9th, the defense moved for an order to show cause regarding alleged contempt by the sheriff's representatives, and the court released Mr. Sanchez Lopez to its own pretrial monitoring program. However, on March 18th, Mr. Sanchez Lopez was arrested again, returning him to custody on 27 felony charges. This was reported by the media as Mr. Sanchez Lopez's 36th lifetime arrest. On March 19th, the day after Mr. Sanchez Lopez's rearrest, a hearing was held before Judge Goodman on the defense's motion regarding the contempt issue. Mr. Sanchez Lopez was not present after the jail declined to transport him for medical reasons, and his attorney, public defender David Westbrook, moved for a continuance. Metro, represented by attorneys Michael Dickerson, Lissa Anderson, and Travis Studdard, opposed the motion.
I believe everybody's here on Sanchez Lopez. Mr. Westbrook, any of the motion you want to make?
I do, Your Honor. As I indicated to the court yesterday via email with all parties on the email, I'm requesting a continuance of today's proceedings, and the reason for that is simple. About 36 hours ago, and my timeline is a little tough. I just got an airplane from Oklahoma. About 36 hours ago, Metro filed a new supplemental briefing. I haven't had a chance to even read it, much less respond to it, and I want to file a response in writing, which I think is our right. All it takes for continuance is good cause, and their late filing is my good cause. There's other reasons that I can present, but I want to start with that one.
That is simply the order that Judge Mendoza actually had. We actually have a written order now.
Well, we have a written order that in no way binds this court, number one, and number two, I need to actually address what the power of that order is. And here's the thing, this came up before, and I'm actually surprised that Metro wouldn't just simply agree to the continuance in this case, since they've been asking for stays nonstop in all these cases. But here's the issue. When we were in front of Judge Mendoza, Metro filed their brief in that case, a 25-page brief with a bunch of exhibits, at 5:50 p.m. the day before the hearing. It wasn't served on us properly. I didn't get it until we appeared for oral argument and it was handed to me. I got somewhere between 20 and 40 minutes to read it. And we were in a situation there where I could not ask for a continuance to fully brief the issue because my client had been ordered by the court onto medium-level house arrest. House arrest refused, told the judge we're not following your order, and said, but you can release him on house arrest. So he was pumped up to high-level house arrest in that case. The problem is that was going to interfere with his job, and he was afraid of losing his job. So I had to go forward then. Also, the sentencing was right around the corner in that case, and it would have damaged my client, I believe that's the case I'm picking up, it would have damaged my client to have the sentencing continued, just because I'm briefing this issue. So I could not, in that situation, ask for a continuance to file a written motion. I got it with about 20 to 40 minutes to read it, and I went up there and argued this brand new issue that I had never seen before, with arguments I had never seen before, on a motion that I was never even served with, and did my best in front of the court. Now, subsequently, I asked the court for an opportunity to actually brief the case, and Metro opposed. So their argument was, you should have asked to continue it, and you should have asked to brief it. You didn't do that, and so we're going to oppose any opportunity to brief it.
Refer to the court. You talk about my court.
Oh, sorry, Judge Mendoza is talking about it. Yeah, I'm talking about the other Judge Mendoza.
I need to keep it straight.
Yeah, I am. So I asked Judge Mendoza for an opportunity to brief it. And I filed a proffer after the hearing of arguments that I would have made had it not been shut down. There was also a lot of oral argument I was trying to make in that case that I was shut down on and Judge Mendoza wouldn't hear. So I was denied the opportunity to brief it in front of Judge Mendoza, and their position was you should have asked for a continuance. Well, now we're in a similar situation today. They just filed something to the court. I have a right to reply in writing. And I'm asking for a continuance because my client's not in a situation where my request for a continuance will hurt him.
Mr. Westbrook requests that the court continue the hearing so that he can respond in writing to a notice of supplemental authority that Metro had filed roughly 36 hours earlier. That filing, submitted on March 17, 2026, attached a written order entered on March 13th by Clark County District Court Judge Erica Mendoza in a separate criminal matter that addressed a similar legal question regarding Metro's authority to refuse to release a defendant under the conditions required by a court order. In that case, Metro declined to place defendant Matthew Cordero de Villa, who had pleaded guilty to coercion constituting domestic violence, on its electronic monitoring program at the level that the court had ordered, citing an unreasonable risk to public safety. And the defense moved for an order to show cause as to why the sheriff's representative should not be held in contempt. Well, Judge Mendoza discharged that order to show cause, concluding that the sheriff possessed the authority to determine whether a defendant could be placed on Metro's program. Notably, Mr. Westbrook and all three Metro attorneys also participated in the Cordero de Villa matter. Now, although Mr. Westbrook was involved in the proceedings that produced Judge Mendoza's ruling, he argued to Judge Goodman that he had not filed written briefing before the show cause hearing in that case because requesting a continuance to brief the issue would have harmed his client, and he instead submitted a proffer after the hearing, setting out the arguments he would have made. Mr. Westbrook argued that a continuance was warranted here because Judge Mendoza's written order had been filed in his case shortly before the present hearing, leaving him without a meaningful opportunity to read it or to prepare a written response addressing its effect. Before we continue, I want to give a big thanks to the sponsor of this episode, Plod. Okay, real quick, this is not a credit card. This is the Plod Note Pro, and it's basically an AI secretary that helps make sure you don't miss something that might matter later. I'm constantly going through hours of footage, depositions, court hearings, and the moment you miss one statement, one contradiction, one key admission, your whole analysis falls apart. And honestly, it's not just in legal work. Situations like this happen all the time in real life. That's why I use this. I hit record, and Plod Note Pro gives me a full transcript with speaker labels, so I always know exactly who said what and when. But what I like most is that it doesn't just record and leave you with hours of audio. It actually organizes everything for you. You get a clean summary, key points pulled out, and you can search through it or even ask questions. Ask Plod pulls out the important moments and lets me instantly find what I'm looking for, so I can go straight to what matters. For example, if I'm reviewing a deposition and need to find where someone contradicts themselves, I don't have to scrub through everything. I just search it, and it's right there. And for anyone concerned about privacy, Plod Note Pro meets enterprise-level security standards. Your data stays yours. If you work with a lot of information, or any situation where what gets said might matter later, this is definitely worth checking out. They also offer a 30-day free return, so you really have nothing to lose. Use code AUDIT15OFF and save 15% on your order. Click the link in the description or scan the QR code on your screen and check it out. Thanks again to Plod for sponsoring today's episode.
So
This case is in front of the Nevada Supreme Court at this point,
yes, it is.
with three other cases.
Yes.
And it's being argued in front of the Supreme Court.
It is being argued in front of the Supreme Court. However, we've all agreed that the contempt issue is not moot.
But that's what happened with Mendoza. She's on higher court, she discharged.
Right, but she's not, she first of all, again, I need to address that in writing. If I'm not allowed a continuance to file a written brief, then I'm in the same situation here as I was in front of Judge Mendoza, and the court would be in a situation where you don't have the full information or the full law in order to hear this argument. And we want to avoid summary decisions. I mean, part of our complaint about what Metro is doing on Mr. Dickerson's advice is that they're making summary decisions behind closed doors, where nobody is present, there are no checks and balances, they don't even have a consistent format for rejecting or accepting people to their program, they won't share the information with us, and we're not allowed to appear and present our case. And what they want to do is turn courtrooms into the little back rooms where they make their decisions.
Is this the motion to continue, Your Honor?
Yes, it is.
What is this on?
It's my motion, okay. Well, I appreciate you calling it nonsense, Mr. Dickerson. I know you think due process is nonsense, but I happen to disagree with you.
I just think that your diatribe here is nonsense.
Mr. Westbrook argues that Metro decides whether a defendant is admitted to or excluded from the release program in a closed and summary process without a consistent standard, without disclosing the basis for its decision, and without any opportunity for the defendant to be heard, and that this framework deprives defendants such as Mr. Sanchez-Lopez of their liberty without the due process that the Constitution requires. Now, although Metro's attorneys did not address the statutory basis for their position during the hearing, a previously issued statement from Metro's Office of Public Information pointed to two statutes. Section 211.252 provides that the sheriff or chief of police may supervise a prisoner electronically rather than confining them physically only if, among other requirements, the sheriff or chief of police concludes that electronic supervision poses no unreasonable risk to public safety. Section 211.300 extends that framework from prisoners to a person detained before trial, allowing the sheriff or chief of police, with the approval of the court of jurisdiction, to supervise an unconvicted detainee in the manner provided for convicted prisoners. Reading the two provisions together, Metro maintained that a court's approval authorizes placement on the program, but does not compel it, and that the statute reserves to the sheriff an independent determination of public safety. Accordingly, Metro determined that the conclusion that Mr. Sanchez-Lopez posed an unreasonable risk was an exercise of the sheriff's statutory authority, and Judge Mendoza's ruling in the Cordero de Villa case agreed with this interpretation.
Here's the thing. Like every local court, I followed the upper courts. Whatever the higher courts tell me to do, whatever they're doing, I'm gonna follow what they're doing. I mean, she did discharge it. I mean, it took a while to get it written, or this wasn't filed until the 13th of this month. That was given to me by Metro, but she could discharge it of her. This is not the exact same issue, but it's adjacent to the issue in front of me. I mean, it's all in the same ballpark. Given that's what Judge Mendoza did, and she's a district court judge, I'm a justice court judge. I mean, I'm just going to dismiss the case down here. I'm going to discharge the order the same way that Mendoza did.
Okay. Well, we obviously object to that.
Oh yeah, of course.
They've agreed to
it up there, you're going to
right
down here.
And look, this is what they're trying to do. They keep sending me.
But you'll be in front of the Supreme Court.
I will be in front
make
of
the decision.
I will be in front of the Supreme Court, but here's the issue.
Yeah.
They keep asking for first of all, Judge Mendoza's order in that case does not bind you in this case in any way, shape, or form. Okay, so let's put that out front right away. And you know who likes to make that argument? Metro. As you might recall, we had an issue a few years ago regarding the subpoena power of defense attorneys, where we had district courts saying that we have subpoena power, and Metro was arguing throughout that those district courts didn't make an order in this case, so therefore they don't apply. Now they're arguing the opposite. They like to argue both sides. Heads I win, tails you lose. That's not what the law allows.
Your Honor, we could stand here and go tit for tat all day long about these allegations.
I am following the written.
Yeah, the
I have the
court has made its
transcript. I have the
order.
transcript. It's instructive, but now the actual written order.
Yes.
That kind of controls down here. Her order kind of controls down here. If anybody wants to make records, you're welcome to make records. But given what Judge Mendoza ruled or her order, I'm discharging this. So if anyone wants to make a record, you're welcome to. But yeah, discharging it.
Judge Goodman states that he is discharging the order to show cause because Judge Mendoza had discharged the order to show cause in the Cordero de Villa case, over Mr. Westbrook's objection that Judge Mendoza's order does not bind Judge Goodman in this separate case. While Mr. Sanchez-Lopez's case in front of Judge Goodman is in the Justice Court, Judge Mendoza issued her decision in the Cordero de Villa case in the District Court, which is a higher level court in the Nevada judicial system. Typically, felony cases begin in the Justice Court for preliminary matters, such as setting bond and a preliminary determination of probable cause, before being bound over to the District Court for the remainder of the case proceedings. Additionally, under Section 177.015 of the Nevada Revised Statutes, final judgments in criminal cases in the Justice Court can be appealed to the District Court. However, this does not mean that Justice Court judges are required to reach the same legal conclusions as District Court judges in separate matters before them. A District Court does sit above a Justice Court, court, but that authority is appellate, and a district court decision is binding on a justice court only when the district court is reviewing a particular justice court case on appeal. In this situation, Judge Mendoza was not reviewing the Sanchez-Lopez matter, but was deciding an entirely separate case as a trial judge. Her order was therefore persuasive rather than controlling authority, and Judge Goodman remained free to decide the contempt question for himself. However, it was also within his discretion to defer to a higher level court's interpretation of the same statutes, despite the fact that it was not legally binding on him.
Well, Your Honor, I'm going to know the record right here.
Okay.
Okay. And this is my record. That is a violation of due process. They have agreed that the issue of contempt is not moot. Your Honor, you're the person who decides whether whether Metro committed contempt in regard to your order.
Well, hold on, I find that even mapped it. I find that even mapped it that they had no basis for what they did. They had a parallel action up in front of Mendoza, Judge Mendoza. It's not this issue, but it's basically the same issue. So when they denied my order, at least they had a basis, because there, at least at that point, there was the transcript. So they had a basis. What if it is nice as an actual order? Yeah, but at least they had a basis for denying it. Then I can't find that they acted in bad faith. I mean, the order came, so I can't find the order they acted in bad faith. So, I mean, I'm discharging this.
Well, you're
not going to find any kind of contempt.
Thank you.
Your Honor, you
Thank you, Your
can't
Honor,
find.
because that is a discretionary decision of this court.
Oh, I know. I read the order from
Your Honor,
Okay.
do you believe they acted in bad faith? Because it sounds to me like the issue that you actually do believe they acted in bad faith, but you feel restricted by an order from a district court that has not made the order in your case. I mean, that's why we're here. It's so that the court can actually rule on this.
They had a transcript where it looked like Judge Mendoza was going to rule this way, the way she ruled.
Okay.
And that's the way she ruled.
And she ruled without even giving me the opportunity to fully brief it.
You're in front of the Nevada Supreme Court.
I am in front of the Nevada Supreme Court. But Your Honor, before you go on, I have to talk to you about my full record, and I have to give you the public interest angle on this as well as everything else. I've already given the legal angle, and I object to it. I think this is a violation of due process. But let's look at what's actually happening here. Metro keeps filing requests for us to agree to a stay of all proceedings on this until the Supreme Court has ruled. And my response to all their requests to stay has been exactly the same. I will gladly agree to a stay of all contempt proceedings in all lower courts if Metro will agree to stop committing acts of contempt. They will not agree to that. They created this completely false narrative in the media, which is designed to stoke fear. Mr. Dickerson is very good at going to the media and telling people to be scared of defendants, when what we should actually be scared of is this Star Chamber backroom denial of people's rights without any due process. That's what we should be scared of. And he knows he's wrong on the law. So he's trying to go out there.
That is plain bacon.
I get to
This
talk.
has been a record.
I get to talk.
This
And then you get to talk.
grandstanding.
And an ad hominem attack, Your Honor. This is not so.
I want you to go back a few sentences and remember what you just said about me. Okay, so the point is, I think he knows he's wrong in the law. And so instead of fighting it in a courtroom, like today, he's fighting it out in the media. And he's trying to use fear. I know that the court's probably gotten phone calls from people with threats. I've gotten phone calls from people with threats. And that's an atmosphere that was created by Mr. Dickerson in the media. Because he knows.
Hold on a second, and don't piss the media. I don't care about the media. My dad has never cared about the media.
Yeah.
I don't really worry about death threats. Doesn't bother me whatsoever. What I worry about, what I care about, is what the district court does. Because we're the lower court.
I'm glad the media is here, Your Honor, because they're the fourth estate, and they're the ones who are going to actually show what's happening behind these closed doors. So I'm very glad the media is here, but the way Mr. Dickerson is
They're
using the
welcome
media...
to. They're absolutely welcome to. They're in here filming this. They're absolutely welcome to do whatever they
Absolutely.
want. They'll do whatever they want.
Then we're in
What I
agreement.
care about at the end of the day is what did Judge Mendoza do?
Yes, and I am asking you for the opportunity, because if you don't give me this opportunity, then your decision is now summary, just like Judge Mendoza's decision was summary. I'm asking for the opportunity to brief this issue that was just handed to me by these guys 36 hours ago. I'm asking them to brief
It
it.
was something you knew was coming for weeks, because you were there for the argument in front of Mendoza, and she pointed to the fact that she was likely to rule exactly how she ruled.
She wrote a 17-page order, which I haven't been able to brief, Your Honor. Okay, listen, Mr. Dickerson's in a great position. because Metro has the ability to go and hire outside counsel to go do their work. All right? These are two private attorneys who are very good at their jobs that Metro is able to use taxpayer money to hire. I am a public defender, and unfortunately,
your job.
thank you very much.
You're very good at your job.
But I don't get to hire anybody outside. I've got a team of other public defenders who also have other jobs to do that are helping me, on this case. But I don't get to hire outside counsel to do all this work. I was just in Oklahoma doing death penalty work that is extremely important because I'm trying to save a life. And I come back here to this and I ask for a reasonable continuance to brief the very issue you're currently ruling on. And if you rule on it without giving me the opportunity to brief it, then it's another denial of due process and it's a summary order. And my question is, what is the harm in letting me present my case? And I'll tell you what the harm is. They're wrong on the law. And so they want to try to debate this case in the court of public opinion because in a court of law, they're going to lose. So they're trying to shut me up. It's like pay no attention to that man behind the curtain. When someone says that, you pull back the curtain. And if you do, you'll find Mr. Dickerson there saying, please, dear God, don't listen to what he's saying because you'll agree with it.
It has no basis in law. He hasn't made any legal argument. That's the
Right.
bottom line. He
I
has
have.
nothing.
Do you disagree that
No,
if I do not
hear this, the Nevada Supreme Court, the Lord is right now, the Nevada Supreme Court.
That's right.
You know what I'm gonna listen to? You know what I'm gonna listen to at the end of the day is the Nevada Supreme Court.
Oh, we all are, Your Honor. That's their job.
Yeah.
But listen, in the
I'm not gonna
meantime,
overturn a district court judge.
they're going to continue to violate clients' rights, and then they're going to go into a courtroom every single time I do a motion for an order to show cause, and they're going to say you can't rule on this, Judge, because Judge Mendoza, based on one-sided briefing and a partial argument in an ambush hearing, ruled in our favor.
All of those comments that is making are belied by the wording of the order, which he apparently has not read.
Right.
Because the Judge Mendoza addresses each and every one of these contentions that he's making. For example, Your Honor, he filed a giant proffer after she ruled from the bench, discharging the order to show cause, with all of the arguments that he wanted to make in response to our brief. And she accepted it and considered it, and that's why it took over a month for us to get that written order. So all of these things, all of these issues that he's raising were addressed by Judge Mendoza before she wrote that order.
So I'm sorry, I think they're saying that I'm wrong on the law and that I'm wrong on what the order is. And what I'm saying is, I can show you that I'm right on the law and right on the order if I'm allowed to file a brief that's responsive to the pleading they filed less than 36 hours ago. So we both agree
No.
that I haven't made my point very clearly and I haven't cited to the law. So I'm asking to do that and they're saying don't let him do that and you're agreeing with them. That's a problem.
Your motion for continuance is denied.
Okay.
If you want to make any kind of record, you're welcome to make a record that you made.
Is the finding that I don't have good cause or is the finding that you think you can't give me a continuance because of Judge Mendoza? I needed to know exactly why.
I was waiting to see what Judge Mendoza did. It's the exact same, I mean, not the exact same issue, but like I said, it's the same ballpark as what has happened to my department. All this is now in the Supreme Court. The Supreme Court will hear this. So save all your energy and all of this for the Supreme Court.
Well, I don't have to save my energy, Judge. I got plenty.
Anything?
No, Your Honor, thank you.
We object under the due process clause, under the rules that allow me to file responses to motions that are filed by counsel.
We didn't file a motion, Your Honor. We filed a notice of supplemental authority, simply giving the court the written order that was in the transcript that we provided to you, and which has been part of the briefing all along.
Okay, it hasn't been because it's a new order. That's just not right.
Okay.
Haven't been given an opportunity to
Case is
respond.
discharged.
Your Honor, thank you.
Now that all this has happened, where's my, oh my gosh. This creates a quagmire.
Well, when Metro violates the law, and it does create a quagmire.
Yeah, Metro, you're free to leave.
Thank you, Your Honor.
Thank you, Your Honor.
Get on my case.
Judge Goodman discharged the order to show cause, aligning his ruling with the district court's resolution of the same question. Mr. Sanchez-Lopez remained in custody following this decision, and as of the date of writing this episode, the case is still pending, with the next setting scheduled for November 19th, 2026. The Nevada Supreme Court case also remains undecided. This case sits at the intersection intersection of two principles that do not easily yield to one another. One is the authority of a judge, after weighing a defendant's record, the charges against them, and the risk of flight or danger, to decide whether a person awaiting trial is released and on what terms. The other is the responsibility of the sheriff, who operates the jail and administers the electronic monitoring program, to ensure that those placed under that supervision can be managed safely in the community. Nevada statutes assign a role to each, and the dispute between Judge Goodman and the Las Vegas Metropolitan Police Department reflects a real disagreement about where one authority ends and the other begins. A controlling answer can come only from the appellate courts, which is where both sides have now turned. Until the Nevada Supreme Court issues an opinion, the question of who holds